What paperwork would you be asked to complete if you wanted to hire our law firm for an injury case? Well, when you come into the office, we first ask folks to fill out our intake paperwork. This includes basic background information about a potential client, things like name, address, phone number, date of birth, and then asks for some facts about how they were injured or what happened, the accident or incident that they're into our office to discuss. Next, the intake materials ask the potential client to tell us about the medical treatment that they've received to date and what kind of lost wages they have and what other types of damages they may have. This is all intended to help us have a more efficient consultation when the lawyer and client are together, so we have more time to answer all of the client's questions. Next, if the client wants to hire us, we have our engagement agreement, which is basically the contract between the client and the law firm. And the engagement agreement goes over several different things. The first is basically the nature of the engagement, that the client is hiring the law firm and that the law firm is going to handle a certain matter on behalf of the client. So it'll usually talk about the date of the accident or the nature of the claim that we're going to be pursuing for the client. Then it will talk about how the law firm would be paid, and we are typically paid on a contingency fee, meaning we're paid a percentage of what we recover on behalf of the client at the end of the case. We're not paid by the hour, we're not paid on a retainer for the case. And most of the time, our contingency fee is 1/3, though there are cases that differ from that. The next section of our engagement agreement goes over the costs. Often our firm will advance certain out-of-pocket costs or hard costs that we would be reimbursed by the client at the end of the case if we're successful. In many cases, if we're not successful, we agree to cover the costs ourselves to the client. But that part of the contract is very important, and one thing that a client should always review whenever they're hiring any firm, because in some of these cases, the costs can be quite high, and with some injury firms, they expect the client to reimburse the costs or front the costs. So you'll always want to pay close attention to the costs portion of the contract. The next section of our engagement agreement goes over the kind of expectations that we have of the client. So it deals with the client's duty to cooperate in prosecuting the case, duty to communicate with us, and update us if they have a significant change, like if they move or change their phone number, so we can stay in touch with them. So it's basically a part of the contract where we set expectations about what the client's role in the process will be. And then finally, we have a provision that says if the law firm determines that the case lacks merit, or we don't think we're going to be able to recover on your behalf for some reason, we have the ability to terminate the engagement. And we would be discussing with you, why and what other options you might have if you want to seek other counsel. That happens very, very rarely, but it is included in our contract. So that's basically the engagement agreement. We try to keep it pretty simple. It's currently at about 2/3 of a page. We've seen other firms where the engagement agreements are 10, 15 pages long and, go into pretty far-fetched scenarios. We want to have a pretty simple, straightforward business relationship with our clients so they know what to expect from us, and they don't have to worry that something's hidden on page 12 in a footnote somewhere of a contract. And really, there are just two other documents that we typically have clients sign when they hire us. The first is something most of you will be familiar with. It's a HIPAA release. It's a very important document because it allows us to get your medical bills and medical records. And we need your medical bills and your medical records to be able to evaluate your claim. So sometimes clients bring us some of their medical bills and records, which is great, but we usually have to request some of the bills and records on behalf of our clients. The HIPAA form allows us to do so. And as a closely related form is the final form that we ask clients to complete when they hire us. And that is what's called a HITECH Letter. The HITECH Act allows law firms to recover, or patients to get copies of their medical bills and records for much less money than under a HIPAA release or the kind of old model. So a HITECH letter is basically a letter from the patient to their doctor saying, I'd like you to send my bills and records to my lawyer. And this actually made a big difference for us and has been a big help to our clients, because with a HITECH letter, we can usually get a large amount of records or all of your records for $6.50. And in the past, we would have cases where an individual provider's records, if let's say you had a long hospital stay, could be $500 or $600. And those are hard costs that would typically be reimbursed at the end of the case. So if we use a HITECH letter for a case like one where in the past it would have been $500 or $600, now we're only paying $6.50, and the client gets the difference in the money. So signing the HITECH letter really helps the client cut their costs, and it's good for our firm, it's good for our clients, so that's why we use that letter. So those are the 4 main documents you'd be asked to complete if you come to our office and you decide to hire us. If you have any other questions, please reach out. Thanks for watching this video.